going to talk about civil liberties, what they are, and how the law has been applied to them. Well, let's start with what they are. Civil liberty is the legal constitutional protection an individual has against the government, not groups of people. Those are civil rights, and they don't protect you from other people. So, for example, if you say something and somebody tells you to shut up, assuming they're not an official of the government, that doesn't have anything to do with the First Amendment or civil liberties. People say this all the time. It's a free country. I can say what I want. Yeah, but other people also get to tell you to shut up. Now, if a police officer or a teacher or somebody tells you to shut up, maybe you have a case because they represent the government. Civil liberties only protect you from the government. They don't protect you from anyone else. The Bill of Rights is the first 10 amendments. These protect basic liberties, things like religion and speech that you're familiar with. There are a handful of these things in the Constitution, as we talked about, ex post facto laws, bills of attainder, writs of habeas corpus, and the like. Here's a fairly blurry chart that's also in the textbook. And we're going to go through all of these one by one, so don't worry too much about reading this right now, but there it is for reference. We'll get back to this. All right. The Bill of the civil liberties, in fact, the federal government as a whole, when it was originally constructed, was only intended to protect you from the national government, not the state governments. And this concept was established in a really important case called Barron v. Baltimore. This is an 1833 case ruled on by John Marshall. And what had happened was a guy named Barron had a dock in Baltimore, and Baltimore put in a drainage system, and it was dumping sediment right where his dock was, and it lifted the bottom of the Baltimore harbor so boats could no longer get up to his dock. So he sued the government under the Fourth Amendment for illegally taking away his property by ruining his dock. And John Marshall said, well, you may have a case, but the Bill of Rights only applies to the federal governments and not the state governments, so you'll have to make your case in state court. And this established an important principle, in the early days of the Republic anyway, that the Bill of Rights only applied to the federal government. Now, this has changed, and that change is caused, most importantly, by the 14th Amendment. The 14th Amendment is the amendment that guarantees privileges and immunities of all citizens, due process of law, and equal protection of the law, regardless of race, previous status of servitude, meaning you used to be a slave. And it applies to the states, because everybody knew at the time that if you didn't force the states to follow these federal laws and grant these federal rights, the southern states would just pass laws discriminating against black people, and so there would have been no point in freeing the slaves. And so the 14th Amendment established the principle that you could apply federal protection to the state government, or to individuals from the state government, I should say. This did not happen until a free speech case coming out of New York State called Gitlow v. New York in 1925, and this is the first time that the Supreme Court said that a federal provision protecting civil liberties had to be followed by the states. Now, they incorporated the free speech part of the Constitution. Now, incorporation is a word we use in government to mean the application of the Bill of Rights, usually, to the states. This has been done one right at a time, and so we call it selective incorporation, because they have picked and chosen which would be applied. They've pretty much all been applied now. Your book will tell you, for example, that the Second Amendment hasn't been applied, but it recently was. The Third and Seventh Amendment and the grand jury requirement of the Fifth Amendment have not been applied, but that's only because all states already have those protections. So there really hasn't been a reason. If they come up in court, the expectation is they would be applied. Most of the application of this selective incorporation happened during the 1960s, during the Warren Court, which hopefully you remember from your U.S. history class. I should say that there are many people, or there's a group of people anyway, who disagree with incorporation, would like to see it undone. For example, Ronald Reagan's Attorney General Edmund Meese in 1985 gave a speech calling for the discorporation, saying that states should be allowed to disobey the Bill of Rights and your constitutionally protected civil liberties. And so, to some extent, there is some debate about this movement.